Hello and welcome to the Department of Energy's SBIR STTR Phase 1 Release 1 Awardees webinar. This webinar is recorded and we will post the recording along with the presentation on our website under Funding Opportunities webpage. Please remember to submit your questions via the Q&A box located at the bottom of your screen. We will take these your questions and submit to each presenter to answer after their presentation. So now we will follow the order of the presentation. I will start with Eileen.
Thank you, Zena, and hello, everyone. I'm Eileen Chant. I'm the Acting Director for the DOE SBIR STTR Programs Office following Manny Oliver's retirement in December. So thank you, everybody, for attending. This is an important webinar, which you learn, especially if you're a first-time awardee, where you learn a lot about how to manage your grant and what the rules are, the reporting, and lots more. I'll go back to the first slide for a second. My email is there on this slide. You can always email me at any time with questions. And the slides will be made available, as well as a recording of this webinar will be made available to you all by email after the event. Okay, I'm just providing a quick introduction before we move on to all the specialists who will provide you with a lot of really great information about your award. And so just at a high level, I have a few introductory comments. One is if you have questions about your award, personnel, or budget changes, you do need to reach out to your grant specialists. And, it doesn't hurt if you have questions and you're wondering about how to proceed on any of these issues. It never hurts to reach out and ask questions rather than head off in a wrong direction. Additionally, if you have questions about the changes to the technical direction of the project, you should reach out to your DOE program manager. They are the technical experts, and they can provide you with guidance in that area. If you have any questions about PAMS, I've provided the PAMS help desk email address. You can reach out to that email address. And then again, if you're not sure who to ask, if you have a question and you're not sure who to ask, or you don't know who your DOE program manager is, or you don't know who your grant specialist is, you can reach out to us, the SBIR STTR email address shown here. We do also have a phone number, and you can reach out to us at that phone number. Going to mention a few recent changes in the program in the last several years. One of them is that technologies that are invented under the SBIR STTR program awards, in the future, down the line, they must be substantially manufactured in the United States. Another new aspect of our program is, and you know this because you have submitted a Phase 1 application as the new awardee, you do have to disclose your foreign relationships, and it must be included with your application. And even if you don't have any foreign relationships, you still must indicate that on the form, sign it, and submit it with your application. And this is important. We do know there's an issue with a large number of applicants not submitting that form. In the future, we are considering declining applications that do not have that form, because it's just something that we have to go back to many applicants for. But another important thing about that form that you should know is that you do need to update your form during the award if things change with respect to foreign relationships. And don't forget, you do in your application, you may have had some unnamed key personnel, a lab engineer, a lab scientist, someone working on the research and development project who was not named in the application, but you do need to reach out to your grant specialist for approval at least 30 days in advance of that person working on the project. So don't forget to get going on that at this point in time. Just like many federal offices, we've experienced a reduction in staffing, and some of our support programs are not in effect at this time. Unfortunately, I'm reporting here at this meeting that we had planned to have a virtual Prince PI meeting scheduled for August. It has been canceled. You do probably have a small amount of money budgeted in your grant for the PI meeting. Mark Soychuk is here, and he is going to talk a lot about budget and what you can and can't do. But my understanding is you should be able to reallocate that small amount of money to other allowable costs in your budget. And we do intend to have a couple of webinars to cover what we consider to be key PI meeting material. So stay tuned and look for those email invitations to those webinars. Again, it will happen over the next few months. Another change of importance is that the DOE TABA vendor contract is no longer in effect. So those of you who were eligible for our vendor should already know that you had the opportunity last month to apply for that $6,500 in funding for their own vendor. That window has passed at this point in time. I did want to provide an update as we did receive a number of those requests, and we are in the process of reviewing those requests. So stay tuned on that as well. Importantly, when you proceed to your phase 2 application, you can request up to $50,000 in TABA services. And that does have to be in your application, in your budget, and you have to select your TABA vendor as a subcontractor to your award. There's a link in here that talks about the use of TABA services and also the phase shift program, which is part of our curriculum today. We are going to have our phase shift vendor talking about the phase shift program right after me. Cybersecurity is becoming more critical in the reauthorization bill of 2022. It was a new provision. It was required that we understand the cybersecurity of our awardees. At the current time, this is only a requirement for your phase 2 application. You do have to complete a cybersecurity self-assessment at that time, but it's never too early to start thinking about cybersecurity. So we encourage you to take some time, review the training, and visit our cybersecurity resources. There are links provided on this page. And if you have questions, you can send an email to that email address at the bottom of the page. Just to mention that and emphasize that in addition to the research and development that you are undertaking to develop technology, the goal of the SBIR STTR program is commercialization. And it's never too early. You did submit a phase 1 commercialization plan as part of your application. Don't neglect that plan. Your business success depends on a successful commercialization strategy. And I'm just going to go through some resources that can help you advance your commercialization strategy. And at the top, I'm just going to mention that you do have supercomputing resources available to you as an awardee. That's not necessarily so much about commercialization, but computing time is available at no charge to you as an SBIR STT awardee. Visit our partnering resources page. Who do you need? You need to think about who you need to partner with to help your project be successful and your commercialization endeavor be successful as well too. You should spend a little time learning about phase 3. It is contract or sales or any work that you get, cash flow that you receive that derives from an SBIR award. So take a little bit of time to understand what phase 3 is. And it does include government contracts that are not SBIR, STTR awards. We have a partnering platform. I call it a dating site for innovators and partners. You can register on this site, and there are a number of partners that are interested in meeting innovators like you. They may be potential customers, they may be commercialization providers, they may be investors, manufacturers, and lots more. I highly recommend, if you're not registered on our partnering platform, you can get on it and you can meet those partners that you may need online. As an awardee, you do need to register as an innovator. I wanted to point out that we have a library of commercialization workshops. These are online, these are recorded webinars, and they are available to you. And they're experts. These are not all government officials. These are private sector persons talking in these areas, people with decades of experience in these areas, providing really great sound advice. So take a look at those webinars. We'll mention a few more areas of manufacturing resources, engineering design, which you'll need at some point to advance your product, test certification resources, commercialization service resources. These links are provided here on this slide. And there are also Department of Energy National Lab resources, including facilities that allow you to test, integrate, and demonstrate your technology. And these are going to be specific to certain technologies. What Oak Ridge is interested in seeing, what Idaho National Lab technologies that they would test, etc. And if you are not familiar with the Lab Embedded Entrepreneurship Program, it's a program that has some synergies with SBIR. Many SBIR awardees also apply and win a spot in this program as well. And that is it for my presentation, and I am going to pass it on. I believe that Max Green is here, who is with Ratio Flux, who is our contractor for the phase shift program, and he's going to talk about the phase shift program. Take it away. Thank you, Max.
All right. Thank you so much, Eileen. Is my screen showing correctly? Does this look good?
Yes, it is.
Okay, fantastic. Well, welcome everybody. I'm honored to be able to talk to you today about Phase Shift 1 program and discuss a little bit about options to continue to participate in it. So for those of you that don't know me, my name is Max Green. I see a lot of familiar names in the program, so super glad to have more folks that are continuing to engage with SBIR and be supported by the programs. I'm an innovation coach by foundationally. I'm one of the instructors to help support the development of the phase shift programs originally. I've kind of evolved my role into being more of a program director and helping support all of our coaches to help guide you. But this really is something I feel intimately passionate about. The type of engagement and the interactions that we have with teams are working to support the entrepreneurship community and helping in the deep tech space to commercialize technology. So that really is our expertise. This is what we do. And we're super excited to continue helping support the Department of Energy. Now, a little bit about the program itself. DOE designed this program to increase the economic impact of the funded research from the SBIR programs. And what we're leaning on is an experiential engagement where we prepare the entrepreneurs, the scientists and engineers in your teams to really think about the opportunities beyond the laboratory. So that's really our key focus. What we're trying to do is eliminate what I'll call like these various elements of failure modes that often happen working in the deep tech space. You are all familiar with these. You've seen these before. And depending on where you get your data, you look at across these. And what I want you to focus on is like the top three, right, on both of these, where it's more than 50% of the total failures really come from really not understanding your customers, right? Not, being able to identify what resources you need within your team and not being able to focus on the types of products you need to be able to support those commercial opportunities. So what we try to do is focus in really quickly to learn how to learn from the market, right? So our goal is to help give you the tool sets and the skills to help support learning fast so that you can make some real rapid failures and continue to evolve your business and your opportunity to launch towards successful opportunities. Now, a little bit about how we do this. We engage in what's called customer discovery foundationally. For those of you that don't have experience with this, we really keep a keen focus on trying to expose very specific questions about who your first customers might be, what challenges they're experiencing, what do they prioritize in a day in their life, what does their business look like, what are their motivations for actually generating a buying decision, helping supporting kind of what you're trying to develop. So just fundamentally understanding who they are and what they're expecting in terms of trying to address the key issues they're dealing with, right? So really getting more formable about that. This sounds pretty straightforward and easy. This is much more complex to put into action. Most people tend to think, hey, my customer is the oil and gas industry or otherwise. And what we drill down into is who are the people that are going to actually make a buying decision? Who are the people that are going to be using your technology to implement something, and why does it matter to them? Like, what is the impact it creates? Now, the way we do this is we work through 7 workshops where we introduce all of these key processes and concepts to you and practice what we call a little bit of intellectual honesty, right? So are we hearing what we believe we are hearing? And can we begin to build a body of evidence to help support decision-making in the business? Now, this happens over an 8-week period where, outside of the workshops, that's where a lot of the work happens, right? So we're going to ask you to practice the process elements, put these tool sets into work for yourselves, and then work to evolve your business model and engagement over time. Now, what we do is we focus on the business model to start with, but what we're looking for is to get a sense of who are those customers and what is the value that you derive for them to determine if there's a desirable opportunity. In other words, is there a customer that has an unmet need that you can help support and deliver a solution to? On the left-hand side of the canvas, while we start to begin to bridge toward this is more of what we'll call the Phase Shift 2 program, is where you start thinking about, okay, how do I put all of these resources together? What types of partnerships do I need to develop? And then work towards actually building a feasible business model. Can we deliver what we say we can deliver and support our customers? And then, of course, across the bottom, looking at the cash flow and our revenue opportunities to get a sense of, can we actually build a profitable model based on all of the cost structure of being able to drive these types of opportunities? Now, in Phase Shift 1, I mentioned we're focused on the right-hand side of this in the blue section. This is really the business model proof of concept, right? Do we have the right customer, the right target, and the right engagement? That's our priority. That's our focus. Now, part of this is, quite rigorous. And what we do is we put a process together, right? So we are teaching a process, teaching entrepreneurs like yourselves to follow the mechanisms to first understand how to establish and identify the assumptions that you're making in the business models. So our coaches spend a lot of time working one-on-one with our teams to effectively begin to get a sense of what matters most, what's most impactful on the opportunity, and if it doesn't come true, what could potentially sink this business. And then we put that through a process which we call customer development, which is effectively using the scientific approach within the construct of the business, right? So where we're very critical about stating very specific hypotheses that are testable, getting out and communicating with the ecosystem so that you can learn how to test those hypotheses, and then working through to assess the data, like really understanding like what are we actually hearing, how do we evolve our approach and begin to continue to learn from them directly. Now, the key here is that this is a mechanism to help you explore the unknown. While you may even come from the industry, you may understand how the industry operates, having a little bit more of a nuanced, detailed understanding about how to explore this really adds value to most of our clients. So when we see this across the board, there's a ton of value that this can generate in terms of being able to continue to utilize these mechanisms. And most people that we talk to, even past the programs, they continue to use these mechanisms quite extensively. Now, this is what we've highlighted with in collaboration with DOE about really what the outcomes are that we're looking for. At the end of the day, all of this talk about business models and what this really informs is giving you the ability to strengthen your phase 2 commercialization plans, right? Supporting you in understanding how to validate those market applications, look at the competitive advantage that your technology enables over others, and communicating that into a narrative that actually represents the delta between you and everyone else. It's not a technical advantage, it's the benefit that it creates for those customers. And then being able to build that into your commercialization plan, looking at the channels, looking at how you're going to make money, ultimately identifying what the alternative approaches might be that help to get you to revenue more quickly, and then increase your chances for funding. So this is what we're really trying to do. All of these different outcomes are foundationally in terms of what you can achieve from this will help to support your business. Now, the DOE has allowed us travel funds for each of the participants to actually come to the workshops, but also to actually get out and go meet with your customers, right? We recognize that your customers aren't necessarily next door to you. They might be in another state. You might need to go to an industry trade show or something like that where you can go to an area of gravity, as I like to call it. So this is an opportunity to be able to go do that as well. So I just want to throw that in there. Now, DOE has extended the application timeline. So I just want to highlight this for everyone that's in attendance today through tomorrow. Okay, so now we are getting really close to having to shut this down because we've got to launch our program in the coming months. But this is at a high level where the application is still available. So please, if you're interested in attending and would like to participate, go to the application link. I'll throw it into the chat here in just a moment, and go ahead and submit an application. We'd love to have you be there. DOE wants to see support as many companies as we possibly can. Now, if you have a question about any of this or would like to learn more, maybe you haven't seen Shanna's emails, you weren't able to attend the original information sessions, feel free to email me directly. I'm glad to connect with anyone that wants to explore this for the value of their business directly. Because we do see this as something that is transformational in terms of being able to support you where you are in your business. It's not just for first-time entrepreneurs. I'll really quickly go to kind of our program commitment here, and just highlight that what we're looking for is to focus on openness to customer feedback, get engaged in the process, learn from what you're hearing from people, and keep your ear to the ground. That's really what we're trying to expose. So what I was just pushing to just a moment ago is to highlight that from your peers, we hear across the board, this is the type of thing that changes your outcomes for your career, right? The opportunities you're looking for in the business, as well as trying to scale and grow and develop your business. It doesn't just stop with phase shift 1. This continues to scale to phase shift 2 and continues to grow from there. Eileen, I think I'm out of time, so I'm going to go ahead and stop sharing there.
Yeah. Thank you very much, Max. I want to just mention that participants can put questions in the Q&A box. Max's time is up now, and I know he has to run, so please email him with questions. But for me or for the subsequent presenters, please pop the questions in the Q&A. And if we have time, during the presentations, we'll answer them. But if not, I can stay until 4:30 to answer questions. And with that said, thank you very much, Max. And the next presenter is Mike Dobbs, who is with the Office of Intellectual Property Law. Mike, you're on now.
Thanks, Eileen. Today I wanted to talk about an important topic, patent and data rights. I want to start with kind of a reminiscent of Ralphie from the Christmas Story theme where we're kind of I want everybody to think about success and where you want to be when you achieve all your wildest dreams with your company and your efforts. And when you're there, think about where your intellectual property is. Are you licensing it to someone else to manufacture it? Did you get patent protection that you then were bought out by another entity, or maybe you don't really need as much, and that you can continue to outperform your competitors. But just think about where you're going to be, and work with your patent counsel to make sure that you are in the right position to be successful and achieve those dreams. Which is really what this slide is really getting at. Make sure you're checking your award terms. And I'm going to skip through these slides, given my experience of close to 20 years supporting the SBIR CTR programs. These are my views, not necessarily those of the department, and not necessarily, your legal counsel's views. So make sure you're using the right resources there. So, as I said, in my experience here, I'm trying to give everybody 4 big things to keep an eye out for, 4 big pitfalls here. One is to properly mark your data. Make sure you're using the SBIR CTR markings only. Report those subject inventions. DOE does have some programs to identify unreported inventions. Watch out for those statutory bars. And then U.S. manufacturing is a growing, with each administration, it seems like there's even more concern and more interest in U.S. manufacturing and protecting U.S. manufacturing for DOE-funded inventions. So let's dive into patent and data rights. First, when I say data rights, I'm more thinking in my mind copyright. This is original works of authorship. It's fixed in a tangible medium of expression, which really means that you wrote it down somewhere, right? Or it's recorded somewhere. It's in something that's tangible. What do you need to disclose to the government there? Typically in these awards, it's just a final tech report. The CO doesn't want to see every single napkin you produced. I don't either, just the final tech reports. And then as far as data protection, those go into the markings. We'll get into those later. But patent rights are a little bit different, right? Those you must, you're going to have an internal process to receive invention disclosures and then work with most likely a patent attorney who's going to draft a patent application and file that at the patent office. And it needs to be something that is new and useful to obtain patent protection and disclosure to the government. Those all need to come in within within 60 days of when you receive them. Those need to be reported into our internal system called iEdison. And then as far as confidentiality, there's a statutory protection for those as well, while we're all trying to figure out if we want to pursue patent protection. So I mentioned data earlier. This has been a kind of a point of confusion in the past. When as a patent attorney, when I hear data, I'm not thinking research data. I'm thinking all recorded information. But again, typically all we're looking for in the government is the final technical report. And then I can't emphasize enough data markings. Make sure you mark. We'll go a little bit more into the different data markings in the next slide, but the key one here is the proprietary data for when you're submitting those proposals and the NOFOs. If you wish to protect your data, make sure you're using the legend that is in the NOFO. All right, for generated data and the performance of these awards, there's going to be 2 categories. The first category is kind of the default. If I have a piece of paper here with no markings on it, it's what we call unlimited rights data. That's unlimited to the government. We have no obligation to protect that. We can publish it, we can use it, copy it, whatever. For this program, we have 20 years of SBIR SCTR protected data. This is statutory. All you need to do is mark it. So when you submit those final reports, if you wish your data to be protected, make sure you include the marking that is in your award terms. And it does look something like here on the top. And then also when you submit it, you'll submit it using our Aussie system. There's a little drop-down box. You can just mark it as 20-year SBIR SCTR data rights. And this is what the legend looks like on the actual final report. And I will share these slides. This is a slide of Austie, what it looks like when you submit it. Key thing there is underneath the intellectual property distribution limitations. If you want that data protection, there is a SBIR data. One note, and this has kind of come up recently, there's some certifications when you submit this. Obviously, the intention here, these reports, we do publish them. If you select the 20-year data protection, it'll be published in, let's say, about 20 years. It'll be at least 20 years. So we don't want anything, any PII or anything. It shouldn't typically be in there. Limited rights data, this is your data that you developed outside of the award, right? That you consider proprietary, should not be in there. Classified information or information that's subject to export control should not be in there. If you feel like you have some export controlled information in there, just let the CO know and we can work through that. So other legends, if you're so inclined and you want to put the little C with the circle around it indicating that it's copyrighted material, that's fine. We do ask on the final tech report that you acknowledge the government license. because again, we will publish it after the 20-year protection period. Certainly want to protect everybody's intellectual property, so do not include anybody's third-party copyrighted material. And as I said, any data that's generated with your private fundings. I've been talking a lot about disclosing to the government and what's on my desk and what you put in OSTI. Make sure you're working with your counsel on what markings to put in when you're disclosing with others. Because as I mentioned, you know, in your dream scenario and your company's a success, you probably don't want your proprietary business data going to your competitors. And so that's where you use things like the non-disclosure agreement. So we've talked about properly marking your data and using the right legend. Now it's time to spend a few minutes to talk about those inventions. And now I'm not talking about patents, but those inventions themselves. So the patent rights, unlike the data rights in these awards, the patent rights are the standard bi-dual rights. This was a change in the 1980s, basically changing the idea. Instead of the government keeping all the invention rights, the institution who comes up with these inventions, it's best to be commercialized by those institutions. So small businesses and nonprofits get to keep their own inventions. And when I say get to keep, it's a key phrase. It's not an automatic thing. There's a reporting requirement, and then you can elect title if you wish to keep them. If you don't wish to retain title to those inventions, you simply not elect. And the government has secondary rights. For various reasons, we typically do not pick up on those inventions, but you certainly have the right to. So when I say invention, I mean, this is right from your award terms, is regulatory and statutory. Invention means, I love this definition, any invention or discovery which is or may be patentable or otherwise protectable under basically the patent code there. So it is incredibly broad. If you talk with your patent counsel about what is patentable, especially with regards to software inventions, probably not going to get a good answer. So I think I would say err on the side of reporting. If it's not patentable, probably don't really care about those patent rights anyway. You're not really losing anything. If it is a valuable invention, failure to report those inventions, the government can seek forfeiture title on those. So inventions are very broad, anything that may be patentable. When I say subject invention, it's a very unique phrase in government IP. It means any invention of the recipient, conceived, you thought of it in your head, or first actually reduced to practice in the performance of work of this award. Notice it doesn't say anything about funding, but it's anything that is conceived or first reduced to practice in the performance of the work. And then this is an award term, but I like to highlight it here. You should be implementing written agreements. So you should have an employment agreement with all your employees that they're going to disclose those inventions to you. And this is not really here to protect the government as much as to protect you. Because as you grow and you get more and more employees, you should have a robust process for receiving those inventions and evaluating those as they come in. So this is kind of one view of what the reporting timeline looks like. You have an invention report, disclose those inventions within 2 months after the inventor discloses it in writing to you, right? And I can't emphasize enough, not just patents. Anytime during the award or after, if you find out about an invention that has been made in the performance of this award, should be disclosed in the IADISON system. The good news is with IADISON is it is an interagency system. The other agencies, several other agencies have signed on to that system. And once it's reported in there, it nags you, tells you what you need to do. There's discussions you can put right in there, and it goes right to the agencies to respond to. If you don't have an ISN account, create one now. All you need is an award number. There's a process. We've been working on streamlining that as much as possible. It's really helpful because during closeout, we'll give you what's called an invention certification. If you don't have an ISN account, it just slows things down. Once you report the invention, you have 2 years to decide if you want to keep it or not. If you want more time to think about it, just ask. And then once you decide, hey, I want to keep this invention, you have a year then to file it. And you can also get extensions there as necessary. So for access IADISON, here is the link here. The IADISON help desk has been very responsive as of late. And then Maritza Rodriguez in my office has been very, very responsive and helpful. She can help you walk through the process if you need help. And here's kind of a broad overview of what the reporting timeline looks like. You have an invention disclosure that you receive from, say, one of your employees through your process. And then that needs to be reported to DOE through IDASN within 2 months. 2 years again to think about whether or not you want to elect title. You can elect title during that period, that's fine. You can think about it, or if you just know you don't want it, you can not elect it and move on. And after your election decision, you have 1 year to file. Once it's filed, it's kind of at the patent office, and that really depends on the technology and on the application. I had in here loosely 1 to 5 years. Hopefully, we'll talk about statutory bars later. Hopefully there's a publication after you file. And then after you file, there is a confirmatory license that once you're an IDASN, you can just click a button in the patent record to generate that confirmatory license. It's just like what it sounds. It's just confirming the government license in that patent. Once you submit it in there, staff from my office will record that at the U.S. Patent and Trademark Office. And then all of these are extendable too. So patent filings, I said once you elect title, you have a year to file. That's that initial patent application within a year. When you work with patent counsel, initial patent application could be a provisional, a PCT, non-provisional. The regulations were updated a few years ago to kind of include all of the above. We just asked for a copy of that, get that confirmatory license, and just let us know if you're going to discontinue prosecution. Your patent counsel should know this, but there should be a government interest clause. Sometimes it's called the government support clause in that patent application. It's really helpful to have that in there. You'll see it on the face of many patents when you look through the Patent and Trademark Office. It's helpful because there is a government license. So if you're working on a government project, that government license would apply to that project. And your patent counsel should know this as well, but the USPTO does provide micro and small entity discounts. So there is also some patent costs are allowable under these SBIR STTR awards. There's $6,500 for the phase 1 and $50,000 for phase 2. Phase 1, frankly, for patent prosecution costs is, in my opinion, not useful because these are 4 subject inventions in this award. So it's very unlikely you're going to come up with an invention in a phase 1 award, report an invention, elect, and then file all within that same time period. But for phase 2, certainly possible. I'd be remiss if I didn't mention too that these TABA funds can be used for things like freedom to operate, right? You have a business plan. We're talking about that dream early on in this discussion. Where are your competitors? And do your competitors maybe have a patent that is concerning that you maybe need to design around, or maybe you need to get a license? That's where you can do a freedom to operate, to have somebody do some research to see what patents are going to be pitfalls for you. And once the award's done, you'll report all those subject inventions in IDASN within 2 months of receiving them. But at the end too, there's a little invention certification there. If you don't have any inventions, you basically have to put your name in the box and then sign it. If you do have some subject inventions, you just list them here. You'll list the DOE assigned number or the IDASN number. Either one works. All right, we talked about marking your data and making sure you're using the legends in the NOFO or the award terms. We talked about reporting those subject inventions, not just the patents. And then we're going to talk a little bit about statutory bars. And this is kind of a bonus to all of you because it's not really just a government patent thing, but this is just really just invention management. So what are statutory bars? That's a bar to getting patent protection if it's patented already, described in a printed publication, or this is kind of the scary part, this is kind of somewhat newer provisions in public use, on sale, or otherwise available to the public. So what does that mean? In the United States, you basically end up getting a 1-year grace period if there's a publication. So in other countries, you don't have a grace period. So in my opinion, it's always the best practice to file those patent applications first and then publish. And you can usually, you work with your patent counsel, but in my experience, there's no reason why you can't file a quick provisional patent application to protect your patent rights to allow you to publish whenever you need to, even if you're in a rush. If there is a statutory bar, you'll need to identify that in IDASN. So we talked about marking your data, reporting those inventions, statutory bars. Now it's watch out for those US manufacturer requirements. This is also kind of a newer thing. It came about a few years ago. Check your NOFO and your award terms. There's some links here to the DOE guidance. Basically, if you Google DOE US manufacturing, it'll take you right to the page. The short of it is these award terms, and this is across the department, they require substantial US manufacturing of all the subject inventions. What that means, there's some interpretation. There has been some effort to try to kind of clarify what substantial US manufacture is, but it's intentionally kind of squishy to allow the parties to kind of some flexibility in how things are managed. But that doesn't mean we're stuck with this. If you have a concern about this requirement, about meeting this requirement, we do have a robust process for waiving or adding clarifications to that. I would caution you that we look for those waivers to be narrowly tailored. What we're looking for in these awards is to benefit the United States and US industry as much as possible. So the first interest is going to be US manufacturing first. And I'll share these slides afterwards. This is what the US competitiveness provision looks like. So next, we kind of have a little bit of a bonus round in working well with others. Just to highlight, follow your award terms. I can't emphasize enough working with your patent counsel or your counsel to look at the award terms, especially when you're looking at subcontracts and making sure you're flowing down the proper provisions. If you're working with one of the laboratories, if you look in the patent clause, the section G, there's a special section there for working with our laboratories, because they operate underneath a DOE Prime Award, and you do too. Can't really flow down the award terms into, from two different awards into each other. So we have to do different tech transfer agreements to accomplish the same thing, giving the same rights. For the SBIR, SCTR programs, we've developed take it or leave it standard agreements to streamline this with our laboratories as much as possible, having terms that fit for the SBIR program and for the laboratory management. And phase 3, I heard Eileen mention that we do have some guidance on that. It is something important to keep in mind, the phase 3 rights you have. There have been, as of late, quite a few questions on SCTR requirements. When you get there, there's a commercialization rights agreement. As part of the awarding process, there's a certification form. Model agreements with our labs. Frankly, I'm not a huge fan of the model agreement, and we did recently update that. I think the intention there is just like I started with at the top of this discussion, is to kind of think about how you're going to have your IP in a good position to commercialize it. Where it doesn't make sense logistically is when we have these multiple award terms flowing through. So to have an agreement before you have the actual federal agreement allocating IP rights, when it's the federal agreement that allocates it, it's just kind of weird and doesn't always work well. But anytime you're having an agreement with the lab or anyone else, just think about what IP could be developed and what are the paths to commercialize that. And that really is the intention of the commercialization rights agreement. And when you're working with the labs, there's a couple tech transfer instruments that are more common, the SVPs and CRADAs. That could be your commercialization rights agreement. And then the other thing I did mention, some considerations for the commercialization rights agreement, consider know-how and also consider equipment. Who's going to own the commitment at the end of the project together? And I'm going to share these slides, but this is kind of, sorry, it's kind of small font here, but these are the different tech transfer agreements at our labs, CRADAs, SPPs, ACTs are somewhat new. So CRADA is a cooperative agreement when you're collaborating. Usually there's some collaborative R&D involved with that. SVP is formally work for others, is when the lab is just kind of usually performing fully reimbursed work for others. And then we have the user agreements. One thing to note, the whole concept of the non-proprietary user agreement is that you're getting computing resources at one of our supercomputers there. If you apply for the non-proprietary time, part of that process is you're agreeing that the results of your research will be published, which may be fine with you, but just something to keep in mind. If you do not want the terms of your agreement to be published, probably more looking for a proprietary use agreement where that is fully reimbursable. So that's all I have for today. I don't know if we have time for questions or not.
Thank you, Mike. We do have time for questions, but there
Excellent.
don't seem to be any right now. We have addressed a few of them, Mark and myself. They didn't pertain to your presentation. But if anybody has any questions for Mike, we do have time to answer. So pop them in the chat. Otherwise, we will move ahead to the next presentation.
Thank you.
Thank you, Mike. Appreciate it. The next presenter is Mark Soika. He is with our Office of Grants, and he's going to talk about post-award requirements. Thank you, Mark.
Thanks, Eileen. Can you hear me?
Yes, I can.
Okay, great. Hi, my name is Mark Soika, and I'm one of two team leaders that work on the SBIR STTR program with the Office of Science Consolidated Service Center in Chicago office. I've been working on this program since 2011, so I do have some experience with the program. And I'm going to talk about an important topic today that I think is just as important as the research that you're performing, and that's the proper administration of your phase one award and complying with your terms and condition reporting requirements. Whether you know it or not, when your company submitted that your application for phase one, you have agreed to comply with all applicable terms and conditions, whether you know what they are or not. So the point of my presentation today is to help you navigate that path and hopefully to educate you and give you some tips to properly administer your award and remain in compliance. So my presentation today is going to talk about some site visit findings, the importance of knowing your terms and conditions, award attachments, revisions to the award requiring DOE contracting officer prior approval, current pending support, disclosure of foreign relationships, and finally the closeout process. Over the last few years, my office has conducted site visits, both in person and virtually, with several phase one and phase two awardees. And the purpose of these site visits was to check for compliance with award terms and conditions. And we also reviewed companies' ASAP drawdowns and supporting documentation. We looked at companies' accounting systems to ensure that they could segregate costs, allocate costs properly, and that DOE wasn't being charged for projects other than what they should be. We also looked at for companies that had equipment under their awards. We looked at property control systems, whether or not you could actually find that piece of equipment that you said you purchased. And we also answered many questions about the program. And so as a result of the site visits, these are some of the issues that we found. Many companies didn't always have adequate support for their ASAP draws. Several of the companies drew down funds out of ASAP prior to incurring the expense. For for-profit companies, ASAP draws are on a reimbursement basis. So you have to incur the expense before you reimburse yourself. When you draw down funds in advance of incurring the expense, that's seen as a non-compliance with your terms and conditions. Many companies also, their systems weren't, I guess, calibrated properly or programmed properly to give us snapshots. So if a company last October drew down $100,000, they cannot point us to what exactly was purchased with that $100,000. They were only tracking when the award started up to that point in time, not just that snapshot of that point in time. So many of the other companies were able to give us what we asked for now that they know what exactly is needed. We also found out that a lot of companies were missing their quarterly financial reports, or that they were being submitted late. And that was a result of companies not having adequate systems in place or reminders or redundancy to remind them when the reports are due. And again, as I said before, a few companies that had equipment, one case, a company couldn't show us where that piece of equipment was. And it took about 2 weeks to find out where it was. And it was at their subcontractor a few states away. So that was highlighting the importance of having an appropriate and robust enough property control system to track that equipment once purchased. Lastly, we found out a company moved. We showed up to the address that I was given the week before, and they weren't there. Well, luckily we were there early, and we found out they were about 20 minutes away, and we're able to meet on time. But something like that, companies should just, if you move or there's changes, please contact at least the grants specialist or the contract specialist working on your award. That'll help everyone. So as I was talking about, there is great importance in knowing your terms and conditions. And when a company is seen as out of compliance with the terms and conditions, there's various remedies that DOE can take to try to bring a company back into compliance. So the range of remedies that DOE can take range from something administratively innocuous or not so bad to something pretty harsh and severe. And this slide describes and shows some things that DOE can do. We would start by first notifying a company via email of reminder of terms and conditions. But if that doesn't work, we can remove somebody from the ASAP system and put a company on invoicing. We can temporarily withhold cash payments. We can offset funds from one award. We can deny future applications, continuation applications, etc. We could also take more harsh penalties by disallowing all or part of the costs. We could suspend or debar or recommend companies for criminal investigations in concert with Department of Justice or the Office of Inspector General. And usually we don't want to go down that far because it's a lot of work for all parties, and that's not really the point of the program. But this is just though highlighting that there are penalties for not being in compliance. And the next slide or two just highlights some actual cases where companies were not in compliance and what the remedies were. And one case under STTR, the research institution has to maintain the minimum 30% research effort. And we found out at closeout that the research institution didn't do that. And so we actually went back to the recipient and recovered about $18,000 in federal costs for that noncompliance. Companies had criminal proceedings, found guilty of fraud, wire fraud, tax evasion, false claims, etc. So that's it takes a lot of time for everybody, and again, we don't want to go down that path. But if something is brought to our attention, we do have to act on it. I'd like to talk about a group of attachments that were included and transmitted to your company when the award was sent to you via FedConnect. The first of which, well, this slide indicates what those attachments were that were transmitted. And I'm going to spend some time talking about special terms and conditions, the reporting checklist, and the general terms and conditions. So the special terms and conditions is a document that's used to promote uniformity in DOE financial assistance and ensure that awards include the appropriate terms and conditions. And as a result, clauses contained in your SBIR STTR award are often the ones found in other types of awards. So the special terms and conditions incorporates the provisions stated in 2 CFR 200 and as amended by 2 CFR 910, which is DOE's specific regulations. And this slide is highlighting just some clauses that I think are pretty important to you in the special terms and conditions. So clause 1C discloses and tells you what your awarded project period is and the dollar amount or government share for that period of performance. Clause 3.2 is the ASAP clause, and the majority of companies awarded under both phase 1 and phase 2 are on ASAP, but there are a few companies that won't have this clause, and they'll have a variation that is for companies that are on invoicing. Clause 7.1 talks about rebudgeting and recovering of indirect costs, and essentially states that we're not going to just do budget revisions or approve them merely to help a company recover their indirect costs. We do understand that funds are limited, but it is a company's, it's at their discretion of how they choose to submit that budget. So if they're intentionally under recovering due to budgetary caps, that is your decision. And over time, we're not just going to revise the budget to change those indirect costs to make you whole. Clause 13, reporting requirements. I do want to stress this clause because it's stating that the importance of complying with your terms and conditions, and it also highlights that failing to comply with the reporting checklist and the required items that need to be submitted will be seen as a material noncompliance, which could have penalties, what I talked about in this few slides prior. Clause 25A, D, and G are included in those companies' special terms and conditions that were awarded equipment in their phase 1 award. The next attachment that was transmitted to you was the Federal Assistance Reporting Checklist, or sometimes referred to as a Reporting Requirements Checklist. And this document it tells recipients what the requirements are to be reported, when they're due, and where you submit them. And I just like to highlight a few requirements that you'll be responding to during the course of your phase 1 award. And the first is the RPPR, or Research Performance Progress Report. And that describes the recipient's progress during the first 3 months of the phase 1 project. A special status report might be required, but often is not. I'm not going to go into that much, but just know that if you do have a special occurrence, that a report needs to be submitted within 5 calendar days of the event. The next big one that affects you is the Standard Form 425, or the Financial Status Report. And during the course of your phase 1, you're going to be submitting this on a quarterly basis, and that's a calendar quarter. And that financial report is due 30 days after the quarter ends. So 30 days after March 31st, June 30th, September 30th, and December 31st. Those are the end of the calendar quarters. A compliance audit is required for those companies that expend $1 million in DOE funds. So it's not $1 million of DOE award value, it's the actual expenditure of DOE funds. And that dollar value changed from $750 to $1 million October 1st of 2024. So that is the requirement in these new phase 1 awards. A life cycle certification is due at least 30 days prior to the phase 1 period ending. And that is, you're just recertifying that you're still in compliance as an eligible small business, that the PI is still working with the company and your company is making progress and still is an eligible small business. And the last 2 things I want to highlight for during the performance of your award are disclosure of foreign relationships and current and pending support. A a question came up earlier during one of the presentations about, is it true that that a current pending support needs to be submitted at least 60 days prior to bringing a grad student on board? And actually, per clause 74CH in your general terms and conditions, there's 2 dates for any current pending support or resume that was previously submitted and that requires a change. That change or update needs to be submitted within 30 days of the change occurring. The 60 days applies to any previously unnamed senior key personnel, postdoc, or grad student. So if somebody was listed as a TBD in your budget, and now you have selected somebody, that resume and current pending support for that individual who is now named needs to be submitted at least 60 days prior to that person starting on the project. And lastly, for this reporting requirements, it also does disclose what documents are submitted at the end of your period of performance. So what's required at closeout. And the right side of this slide does indicate a final 425, so a final financial status report, a final patent certification, a final property certification, regardless of if you have equipment or property or not, a final technical report, and as Mike Dobbs indicated in his presentation, that final report should not contain any PII, export control data, or any sensitive data. And finally, that life cycle certification that was due 30 days prior, if you didn't submit it when you should have, we'll be asking for it at closeout. So I touched on the general terms and conditions briefly, but again, this next attachment highlights those requirements from 2 CFR 200, which are especially pertinent to research grants in general. However, the GTCs don't represent an exhaustive list of all requirements associated with your award. But I'm just going to talk about a few, I think, that are pretty important and are typically those areas that my team receives questions on. And some of those topics are revisions requiring prior DOE CO approval. Again, current pending support, reporting of disclosures of foreign relationships, property, any kind of participation requirement, level of effort by the awardee or the PI. And I'm not going to talk about any patent rights or rights and data questions because my predecessor here, Mike Dobbs, so eloquently addressed this topic, and he's the expert. So I'm going to defer to him on those topics. But some clauses are clauses GTC 4, which is revision of budget and program plans, GTC 9, extensions, and GTC clause 12, affecting the principal investigator. Those can all be grouped together as types of revisions to your award. And these types of revisions can cause problems because these all require DOE prior CO approval. So if you make these changes without that prior approval, you could be in trouble. And to what degree depends on the situation. So I'm going to talk about some changes that require prior approval by the DOE CO. And again, changes to the PI or key personnel are a pretty important change. And as the clause in your general terms and conditions indicates, both of these changes need to be submitted via the portfolio analysis and management system, or PAMS. So that's that electronic system that you that is used by the programmatic staff to track your award, et cetera. And so those requests need to be submitted via that system. So when you're wanting to request a change to the PI, that request that's submitted via PAMS, in the request, you need to address how you're going to handle the current PI of your project. Is that person going to remain on the project in some other capacity, or should they be removed totally from the project? And also with that new PI, you need to attach the resume and current and pending support. And both of those documents need to be certified by that individual. And we also do ask that these requests via PAMS be submitted by your company's recipient business officer. And that if that person is separate and distinct from the PI. And the reason that we prefer to deal with that person, if separate from the PI, is this person typically is more familiar with terms and conditions and the requirements of your award outside of the research being conducted. And now I'm going to talk about some other changes that require prior approval. So if you have any changes to subcontracts, or you want to add a subcontractor, we ask that you first contact our office and obtain prior approval. And I do want to specify and clarify that these prior approvals are from the DOE contracting officer. So I'm one of them, and there's 4 others amongst the 2 teams that process these applications. Prior approval cannot be made or granted by a DOE program manager. So I know some people like to conflate the two, but there is a drastic distinction. Program managers do not have the authority to approve changes. They can only concur or not concur with any proposed change. Other revisions requiring prior approval are novation agreements, where there's a change of assets and liabilities, a change of name agreement. If you're proposing work be performed outside the United States by a subcontractor or a consultant, you need prior approval for that. And lastly, the last change that I'm going to talk about is no fund extension. That typically is the biggest change that we receive the most questions and requests for. So I'm going to spend a little time talking about that. So first and foremost, approvals for no fund extensions will not be granted for an award that contains a $0 balance. So if you've exhausted all of your money on the award, we're not going to grant you a no fund extension just to keep it open for lines of credit, etc., for whatever reason. And also, recipients are not authorized to grant themselves an extension. I know 2 CFR does allow for certain entities to do that, nonprofits, institutes of higher education, nonprofits, etc., but not for-profit companies. For-profit companies cannot grant themselves a no fund extension. So again, prior approval by the DOE CO is required. And as I stated earlier, requests for no fund extensions need to be submitted via PAMS. And we ask that you do that no later than 10 calendar days prior to the expiration date. In that request, please indicate the project status, the reason for the extension, what your new proposed expiration date is, and the remaining grant balance. Next topic I'd like to talk about is current pending support. It was briefly touched on both by Eileen Chant earlier in her discussion. And as I mentioned a little earlier too, the big takeaway for that is when you submitted your application and for your PI, senior key personnel, any postdocs and grad students who were named, you provided a certified current and pending support and a resume for that person. And this clause is just restating and highlighting the fact that any changes to any current pending support or resume CV that we have seen, we have reviewed, any changes to those documents needs to take place within 30 days of that change happening. And as I stated before too, if you had a position that was TBD, whether key personnel or some other general engineer or whatever labor category that was shown as TBD, and you didn't submit a resume because you didn't know who that person was yet, that requires 60 days prior notice and submission before that person can be brought on to the project. And the whole point of this exercise is that allows DOE and its staff to search for any potential duplications, over commitments, any conflicts of interest or commitments, or any other sources of support. And lastly, the disclosure of foreign relationships. Eileen also touched on this, but all companies did submit a disclosure with their application. And we're just highlighting here that any changes to it prior disclosure needs to take place within 30 days of the change happening and 30 days prior to the end of the phase 1 period of performance. And you'd be submitting that with your life cycle certification. If you fail to disclose any foreign relationships, there's a difference of remedies that DOE can take. It kind of depends on intent. If you intentionally fail to disclose, we can kind of come after you more severely. We can either terminate, make criminal referrals, etc. If it's kind of just an omission, accident, it might not be as severe, but it is still seen as a material non-compliance with your terms and conditions. So again, the whole key of this presentation is education. You do need to take the time, read your documents. I know it's boring, but that's the condition of receiving financial assistance. There are strings attached to the money that you're receiving. So, and as Eileen stated before, I think Mike Dobbs did too, if you have questions, please ask. It's better to do that before something versus after, because afterwards it might be more severe and remedies, we might not be able to work with you as easily. So after your award is done, now what? Closeouts. This slide highlights those items that are required to be submitted at the end of your award. The final technical report, that's due 14 calendar days after expiration. A final financial status report, that's due within 120 calendar days after expiration. If you can get it sooner, please do so. Final patent certification, as Mike Dobbs mentioned, is due 120 calendar days after expiration. The same with a final property certification. And that document is required regardless of if you have property or not under your award. A life cycle certification, as I mentioned, if you hadn't done so 30 days prior, like you should have, we'll be asking for it at closeout. And lastly, almost lastly, sorry, a disclosure for your tablet services, that report, and that's due annually with your final technical report. And as I mentioned before, also your disclosure of foreign relationships, and that's due 30 calendar days prior to expiration. So when in doubt, again, always follow your reporting and checklist instructions. Lastly, this slide is showing some points of contact for various questions. If you have questions regarding your terms and conditions, anything regarding budget changes, PI, personnel, etc., please reach out to your grants management specialist or contract specialist in my office. That's the person that you dealt with getting your award in place. Any questions regarding programmatic or technical questions, please reach out to your DOE program manager. That person is listed on page 2 of your assistance agreement. The same is true with your contract specialist or grants management specialist. They're also shown on page 2 of that assistance agreement. And again, all those documents are transmitted to you via FedConnect. We do get some questions from people like, "Oh, I can't access anything in FedConnect." Initially, only one person is set up to receive the information for the company. Others can be brought on board via joining the team. If you have questions about how to do that, please reach out to your specialist under the award, grants specialist or contract specialist, and they can provide you the information on how to add more people to view the documents that were transmitted to your company. As Mike Dobbs might have pointed out, any questions regarding patents and intellectual property questions can be directed to Cindy Ridge. And I'm sorry, her phone number here might be incorrect, but I do know that her email is correct. I apologize for that because I think it changed recently. And lastly, any questions regarding the PAM system, please reach out to the PAM's support center at either the phone number or email address shown here. And again, as Eileen mentioned, my slide deck will be provided afterwards. So with that, I'll
Thank you, Mark.
open it up to questions.
Yeah, I really appreciate it. There are some questions. And I did want Zena to clarify, because I may have put something wrong in the Q&A box. How is it that you're going to provide the slides and the webinar recording? Are you going to provide a link, or how will people access it, Zena?
Thank you, Eileen. For now, I put that we will post the recording and the presentation on our website under the Funding Opportunities webpage. That's how we normally do it. So just for all the attendees, please be patient with us until we download the recording and make sure everything goes smooth, and then we'll post both the recording and presentation on our website.
Thank you, Zena. And I should have deferred to you. You're the expert on this. So yes, go back to our Funding Opportunities page for that information. Yeah, there are a bunch of questions from Mark, and this first one is there's a couple that are along the same lines, and this was an important issue, I think, because we do appreciate all your patience with these awards beginning. There were, because of the incoming administration, there were a number of pauses in our processes that caused delays. And so there's a little bit of confusion about the award date showing in February, but the grant didn't start until April or May. And that, I think that verbal report that's due. So the award was dated for an award date in February, did not receive the award until April. When is the first report due? And that, I think, refers to the verbal report with the program manager. What would you say to that, Mark?
Well, as in years past, when there's delays, first I would reach out to the program manager and discuss this situation. I see this more as a programmatic issue in terms of, adequate progress, etc., which is usually for phase 2. But I mean, the project start is the project start. If there was a delay for whatever reason, and you've only accomplished what you've accomplished, I think you should still have that contact with that person 3 months after the start and let them know. I mean, more than likely, there's going to be a resulting no fund extension at the end of phase 1 for these purposes. But I mean, we're not adjusting start dates, and that's how it's been the case. This isn't the first time that there's been delays due to incoming or changes in administration. So I just would leave it at that.
Yeah, and also, thank you, Mark. Also, just to point out that this is a fairly informal requirement, and I think Mark's advice is just to stay in touch with your program manager on it and find out how they want to handle it.
I do see questions about TALA. I think there's two things that I think I can address, and so the question was, how can we go about maybe changing a tablet provider? Different from what's proposed during the phase 1. So if you were awarded with a tablet provider in that additional $6,500, and for whatever reason you want to change, that would submit a request to your grants management specialist or contract specialist with that change, why the change, who the new proposed tablet provider is. So we need a letter of commitment for them, and the basis for their for the cost being requested or left. And then the question was, how about a change for TAP in phase 2? Well, it's the same process. In both phase 1 and phase 2 now, LARDA is not there. So if you were awarded TABA costs under your phase 1 or phase 2 with somebody and you want to change them out, that requires a request to your specialist for that change, and we'll act accordingly.
Thank you. There's a question about the format of the report, the progress report at 3 months, and it's really just to reach out to your project manager and you can arrange that format. It can be a phone call, it can be a webinar, a Teams meeting, etc., but it's just a verbal progress
But
report.
I would also highlight in the reporting checklist, the first 3 pages are a bunch of information, and then there's about 15 to 18 pages beyond that, which is standard for all recipients. The information included there does address what types of information need to be included or addressed in the various reports, final reports, etc. So we've got questions before of what's the format of a final report? Well, there is no prescribed format. We just indicate what elements addressed in that final report. And so again, please read the whole reporting checklist for the information that's required.
Okay, next question. Is it typical for RPPRs and SF425s to be required for submission after the final report of a phase 1 is submitted? The difference in research periods and admin periods has caused some uncertainty when the FARC requires quarterly submissions. That would be quarterly submissions are not required.
Well, no, a quarterly financial report is required during the performance of the award. After the award ends and you've submitted a final, you don't need to submit another quarterly because you've said it's a final. So we do recognize that companies may not be able to wrap up their final report within the period of performance. So sometimes some costs might be incurred strictly for working on the final report after the end date. So again, that should be very minimal amounts of funding to wrap that up. I don't know. I think that might be what that question was.
Yeah, I think, yeah. Okay, the next question is phase 1 award a fixed cost? And if so, if there are funds remaining at the end of the performance period, what is the mechanism for claiming them?
Okay. Well, unfortunately, this is financial assistance. It's not a contract. So therefore, any award under $250,000 is not a fixed award or a fixed cost award, fixed price award. It's a fixed amount award. So, and even with that, there's a distinction. Just because a company received $200,000 for a phase 1 doesn't mean they can do whatever they want with it, possibly like a contract under firm fixed price awards. So the answer to the question is, if you had a $200,000 award and you're done and there's $5,000 left, DOE is going to deobligate that $5,000. Any remaining phase 1 funds cannot be used on phase 2. Just like any remaining funds on phase 2 cannot be used on a phase 2A or phase 2B or phase 2C. They're separate and distinct periods of performance. So that phase 1 remaining balance will be deobligated. It's not yours to keep.
Okay, next question. If an award is issued with the POP start date in the past, i.e. award issue 5/15/25 with a start date of 4/1/2025, will DOE be able to adjust the period of performance start date in the future to allow for amount of time contemplated in the budget? Recently, there have been awards issued late that effectively reduce our phase one period of performance from 6 months to 4. This has resulted in no cost extension requests and some confusion on deliverable due dates. Well, number one is that you will be able to request a no cost extension on your project. And of course, we understand that the delay in the funding being available is, going to have an impact on your ability to complete your project on the timing. But you do have to keep in mind that you do need to be completed with your phase one award. Assuming you're going to apply for phase two, you need to be have completed your project by the start of the phase two award, the grant start date for your phase two award. Mark, do you want to add anything to that?
I think you pretty much addressed what I was going to say, or what I would say. We're not going to adjust the start date. If extensions are required, we can address that on the back end. I'm
Yeah, and
seeing,
right now the phase two release one grant start date is in April of 2026. So you do have 11 months at this point to complete your project, and that is assuming that everything starts on time. So that's your minimum time. That's the time you should really target for completing your phase one. If you require a no cost extension, of course, you're going to have to ask for that as well. Oh, and when, does someone want to say something?
no, I was just reading one of the other questions. So why don't you go ahead?
How and when can we reimburse the fees that we include in the budget, which is not directly associated with the spending?
Like, if a company had fee or profit in their awarded budget, when a company does their ASAP draws for their expenses, which should be no more frequently than every 14 days, and at a minimum should coincide with your company's normal billing cycle. When you draw down funds to cover those costs, you should also be including a proportionate share of fee with that draw. So if you had a 7% fee that you should, and you're drawing down, say you had $35,000 of expenses that you're drawing to reimburse yourself for, you should also be drawing down 7% of that 35,000 to cover that fee. So you should handle fee proportionally during the life of your draws of the phase one period, not waiting till the very end, because you may not have anything left.
And that's true for overhead as well. It's a proportional.
Right. Indirects, fringes, G&A, et cetera, all that, those percentages, you should be doing proportionate shares in your draw to account for indirects and fee.
Yeah, and you can't get advances on those.
Correct.
Funds.
And talking about advances, just briefly, I do receive questions on occasion from recipients about national labs. The statutory requirement for advances of funds to a national lab from a small business is no more than 30 days worth of funding. I know some West Coast labs, even though they've been reminded, might still be requiring 45 days, 90 days worth of advance for expenses. If you get a request like that, the answer is no. You should only be advancing or doing 30 days worth of their expenses, and that's via statute. So I do realize that, again, it's reimbursement. So you're going to have to, and if you're on a cash basis, you're going to have to cover those costs out of your own funds before seeking reimbursement out of ASAP. If you're on a basis, you can draw down those funds when you book that expense.
Okay, next question. Thank you. Eligibility to apply for a phase two grant requires an active phase one award, if I understand correctly. However, the FOA for phase two, release two, has not been announced yet. Will a no-cost extension be permitted in order for Phase 1 recipients to apply for the Phase 2 grant? Now, please take note that this is, you are a group of Phase 1, Release 1 awardees under fiscal year 2025. You will be applying for the fiscal year 26 Phase 2 Release 1. You will be applying for your Phase 2 award under next year's Phase 2 Release 1 NOFO, not the NOFO, the Release 2 NOFO that is delayed and hasn't come out yet, but is going to be coming out. So make sure you understand which NOFO, and you will be invited to apply for the correct NOFO. You won't receive invitations for the upcoming Phase 2 Release 2 NOFO. Does that help? You can go to our funding opportunities page and see the projected date for the 26 Phase 2 Release 1 NOFO. Will the date of the Phase 2 proposal, 9.5 months after the start date, be adjusted to reflect the delayed start date? At this point in time, we don't anticipate doing adjusting it for that reason, because as I was mentioning before, at this point in time, the Phase 2 grant start date is going to be is 11 months from now. We do feel that it is enough time for you to finish your Phase 1 award. Now, note that you won't be finished with your Phase 1 award when you're submitting your Phase 2 proposal. And you do have to submit an interim Phase 1 report with your Phase 2 application. So you do kind of want to plan your research strategy so that you can have some key results that will be helpful in your Phase 2 application. When will we receive instructions for submitting the Phase 2 proposal? Again, it's going to be on the funding opportunities page. Let me just quickly look up at that date. The NOFO for you all, the Phase 2 NOFO is scheduled for October 21st. And we will be in contact with you all by email. You will be invited to webinars to talk about the application process. And you will receive a notification when the NOFO is released. I think this next one is the same question. Our award has a similar issue, began in February officially, but we didn't start till mid-April. Do we need to complete an SF 425 for the first calendar quarter? The answer to that is yes, we've answered that. Is that correct, Mark?
I'm sorry, I was typing a response.
Yeah, they do need to submit SF 425 for the first quarter that ended.
Yes.
In March.
Yeah. If they've been awarded, yes.
February, March, it would have been April, the first quarter.
No, January, February, March.
Oh, January, okay.
Right, April, May,
It's
June.
the calendar quarter. Okay, thanks.
Right. I did go through that in the presentation.
Thank you. I'm still on a learning curve as the new director, so
That's okay.
glad you're here, Mark. So the next question is, thank you for responding to my question on our PPRs and 425s. We were asked to submit both reports after submission of a final report recently, which is why the question was asked. The contract specialist stated this was a requirement, even if the RPPRs state nothing to report.
I mean, the reporting checklist indicates 3 months, like, if your period of performance is 9 months, you're only required to submit an RPPR after 3 months. If you have a 12-month period of performance, you would have to submit 2 RPPRs, one after 3 months, and then 9 months after that 3. So that after month 12, you would need to submit an RPPR as well. That's possibly what they were talking about.
Okay, last question, that'll kind of put us right back on time and ready for Sarah's presentation, but it is, are pre-award expenditures allowed for Phase 1 or only phase two, the less than 90 days?
I'm gonna address this and say, first off, any pre-award expenditures are at a company's own risk. We don't pre-approve anything. If a company wishes to incur pre-award costs, either phase one or phase two, that's at the company's own discretion. They also have to realize that just because you expend it doesn't mean we have to pay it. We're not granting prior approvals. If a company is working with a specialist and the award's close, and if a company wants to start working that because they think they're going to get the award, that's their prerogative. We're not going to say go ahead and incur them. That's at a company's own discretion. And however, just be aware that things can change. We had a case last fall where a phase two company thought they're getting the award and started incurring, and then they became ineligible. And so we had to disallow those costs. So pre-award costs typically are phase one only. I've never had it asked for phase two. I would not recommend anything with phase two prior to award. Pre-award cost typically is a phase one concept. I'll close with that.
Thank you, Mark. Are there any other questions? We have time for one or two more for Mark before we move on to the next presentation from the Office of Inspector General. I am confused. I thought the 3-month RPPR was just a verbal check in with the program manager. Are we supposed to submit something? I think the answer to that is no. Carl, do you want to confirm that?
I would agree. I think the 3-month session with the program managers was when we had the PI meeting.
But I still think that the awardees are required to do it. They just will be doing it via a webinar or a phone call.
I agree.
The format it's a verbal presentation. So while certainly slides would help, I'm sure, I don't think there's any formal reporting requirement there.
Yes.
Okay. Sounds good. Thank you very much, Mark. Next up is Sarah Hinderer, and she's with the Department of Energy's Office of Inspector General, and her topic is on preventing fraud in the SBIR STTR programs. Sarah?
Hi, how are you? Do you want me to share the slides, or are you, I didn't know if you guys were going to share them.
I think everybody's been sharing their own slides, so if you are okay with that, can we do it that way?
Let me see if I can get that up. Give me 1 second to do this. All right. Can everybody see the presentation?
Yes, I see it, Sarah.
Okay. So my name again is Sarah Hinderer. I'm with the Department of Energy's Office of Inspector General. You can say DOE OIG or just the OIG. We often reference ourselves as the OIG. And what we do is we do waste, fraud, and abuse investigations. So anything that would be fraud against the department, being DOE, that's something that the OIG would take a look at and investigate. And so we'll just kind of start at the very beginning with the SBIR program. And when we're looking, some of the things that the OIG does when we're looking at combating fraud within the SBIR program is we're going to start with the application process. And we're going to look at all the documents that have been submitted in the application process. And we're going to look to see if anything that's been submitted is fraudulent, if any of the forms that are submitted, if there's any lies on the forms. And there's also, just so you know, on one of the forms, it does say that if you provide any false statements, that you can be criminally charged. So that's something to keep in mind, that the OIG, we are law enforcement. We do have the ability to prosecute fraud cases, criminal or civil. And so that does happen, and it has happened with SBIR cases before. But we'll start with the application process. And basically some of the things that unfortunately sometimes occur is that there might be a plagiarized proposal. So again, make sure that this is your work, that you're not submitting anything that's been plagiarized, that you're not using from another company, because that is considered you lying to the department. Providing false information regarding the company, the principal investigator, the PI, or the work to be performed. So if you say Jane Doe is going to be the PI, then we expect that Jane Doe is going to be the PI. And I know it's been discussed before, if there is a change in the PI or key personnel, make sure that you are conveying that information and getting that approval with the department. Otherwise, we would consider that to be fraud. And also seeking funding for work that has already been completed. That's another thing that we'll take a look at in the application process. And then during the award, we look at things like, are you using the funds for personal use or for anything other than the proposed activities? And I'll talk a little bit later about a specific case that we worked. But, if you're buying a house, if you're buying a boat, with these funds, those are things that are typically considered unallowable by DOE. And those would be things that we would take a look at. Submitting plagiarized reports or reports falsely claiming work has been completed. That's also another thing that we will take a look at as well. And also claiming results for an award that were funded by a different source. So one of the big things is, a lot of times people who are getting funds from DOE for these SBIR awards may be getting funds from NSF or NASA or, or another federal agency. And the biggest thing that you want to make sure is that you're not duplicating work and that you're being truthful with DOE if you do have funding with another federal agency. And one thing that's not on this slide, but I do want to point out, is we also look at the closing documents. So some of those certifications that you're going to send in at the end of the award, we will take a look at those and we'll verify that the information that you have listed on those documents is truthful. So if you lie on any of those documents, that's considered a false statement. That is fraud. And then knowing the rules. These are some of the things that we think at the OIG that you should be particularly aware of. Duplicate or overlapping proposals may not be submitted to multiple agencies without full disclosure to all agencies. And we talked a little bit about that in the last slide. And also the requirements for SBA. So making sure that your small business meets those criteria. If you have any questions regarding if your company is eligible to be considered a small business, please make sure that you are talking with either DOE or SBA to make sure that your company falls within their requirements for that. For SBIR, the PI's primary employment must be with the company during that grant period. So this is your period of performance. And the PI may not be employed full-time elsewhere. And this is something that we do see that happens, unfortunately, in some of the grant fraud cases that we take a look at. Again, if there's an issue with a PI and you need a PI change, make sure you're working with DOE on that. Also for SBIR, for phase 1, a minimum of 2/3 of the research effort must be performed by the grantee company. And that's something that, you want to make sure that you're adhering to, because that's one of the things that we will look at. I won't talk as much about phase 2 since you are all here for the phase 1. But that's something for you to keep in the back of your head. University employees participating on an SBIR award should disclose their involvement to the university, as well as their use of university facilities. And then one of the big things that we unfortunately find sometimes is that the research and development has been performed outside of the United States, and it must be performed within the United States. If you have any questions about any kind of research and development, about where that's going to take place, please reach out to the department so you can make sure that you're complying with their regulations. What happens if you break the rules? So as I said before, if you lie to DOE, that's considered a false statement, which can get into other criminal statutes or even potentially civil statutes. Lying is what is going to get you, into some trouble if you do that. So we do investigate that. We've had a number of SBIR cases, just even during the time that I've been with DOE OIG. And we do work with the Department of Justice on our investigations. So if we believe that there has been fraud within an SBIR proposal or work that's being done in award, we can refer that over to the Department of Justice, and they are the ones that would potentially either prosecute the individual, the company, for either criminal statute violations or civil statute violations. And there's different criminal statutes that we can use in order to go after businesses that commit fraud against DOE. I'm going to go into an investigation that will hopefully kind of explain to you some of the things that we look for in the cases that we're working that are SBIR grant fraud cases. And this was a case that I had. It was a small business. They had originally a phase 1 award with DOE. They had a subcontractor at a university. They moved into the phase 2. They were having issues during the proposal for the phase 2. And ultimately, the owners of the company decided to submit a false document to the department. So that's considered fraud at the inception. So please do not submit any fraudulent documents to DOE, because if you do, that is considered false statements. That is fraud. And after they made that first fraudulent statement to DOE, they continued their fraud schemes throughout the course of the award. The owner of the small business ended up using department award money to get an MBA. She also used award money to purchase a house. And those were things that were deemed unallowable by the department. So again, when you're using the money that you've been given by the department, make sure that you're using it on allowable costs, not unallowable costs. If you have any questions as to whether something is allowable by the department, please reach out to your contracting officer or your program manager or somebody to verify if those costs are actually allowable. Also, they used that Fed award, which ultimately was deemed that they should never have received the phase 2 SBIR award because they committed fraud in order to do so. So everything after that became an issue. So they had a state matching grant, which you needed the federal grant to get the state matching grant. So that got tied into everything as well. And also they lied on their final certifications. And as I mentioned before, that's an issue. We do look at the final certifications. So when we were going through their financial records, we could tell that things that they had reported on those final certifications to DOE were not accurate. And so those were considered false statements as well. And this was an investigation where, and also after the period of performance ended, the or the small business owner had funds left over from the award. She had drawn down everything from the account, and she had money in her bank accounts, and she kept that money, even though she knew that she was supposed to return it to the department because it was unused grant money. And so that was another issue that this business had. Ultimately, you know, there were two subjects of the investigation. The one subject, he decided to plead guilty. So he ended up being sentenced to 6 months in prison and 6 months home detention, as well as restitution. And he also had awards from EPA, EPA. And so we worked with EPA OIG, and EPA also went after this individual and was able, because there was fraud with those awards as well, and they were able to go after this individual for that award money as well. So he was also subject to restitution. And then the other individual, she decided to go to trial. She ultimately was convicted at trial, and she ended up getting 42 months in federal prison. So committing fraud on an SBIR grant award, you can end up going to prison for that. So that's just something for you to keep in mind. And she also was held responsible for restitution of the award, and not just for the federal award, but also for the state matching grant. And so they're both on the hook for the $1 million that they got from DOE, and then she was on the hook for the $500,000 that she got from the state. This is something that went up to the Sixth Circuit Appellate Court, because they both appealed their restitution, and the appellate court upheld the district court ruling, which was that because there was fraud at the inception. So remember that they submitted the fraudulent document at the beginning in their proposal. They were responsible for paying back to DOE the full amount of the award. So that is now case law. And it actually, there was a recent SBIR case involving DOE and NSF, and the court ruled, and they used this case as the case law for theirs for sentencing. And the judge agreed that they were responsible for repaying the full amount of the award. So keep in mind that if you do commit fraud, you are potentially looking at prison and also restitution, potentially for the full amount of the award. So this is just a case that we use as a cautionary note of why it's important not to lie to DOE when you're applying for the award, when you're in your period of performance, and how you're spending the dollars that DOE gives you, and then also on your final certifications. And then lastly, this is our contact information. So we have a hotline, which people reach out to our hotline all the time to submit complaints for all different things regarding the department. And you can either do it anonymously, or you can provide your contact information. And this is a way for us to just, you know, get information of things that may be going on, you know, fraud, waste, and abuse against the department, that we will take a look at and determine if there is an issue. We have both an investigative side, and we also have an audit side. So sometimes if it's not something that we would take on the investigative side, the audit side might take a look at it as well. But please, if you are aware of any waste, fraud, and abuse against the department, feel free to reach out to our hotline, and you can provide that information. And if you want, we like if we have a complainant, that way we can reach back out to somebody. But if you don't feel comfortable providing your information, you can absolutely do it anonymously. So, and that is all I have.
Thank you, Sarah. There's just one thing that I want to add, is that you do receive the grant for conducting the scope of work that you said you were going to conduct in your application. You know, fraud is about, of course, as Sarah covered, about lying, plagiarism, duplication of work. But we do understand that with research and development, sometimes things don't work out the way that you plan them to work out, and you do have to pivot your project and change your scope, revise your scope of work. And that's just another situation that's very important to reach out to your program manager and discuss, and the, of course, the contract officer as well, in order to, get permission to shift your focus of the project. So just wanted to mention that as well too.
And I would just like to add on to that is something that we do look at in our investigations. Did the business reach out to the department to get approval for whatever changes that were made? And if it's yes, they did, and the department agreed to it, then we're good. So Eileen makes a very, very good point.
All right, that concludes our presentations. I can stick around for a couple of minutes if there's any other questions. We do appreciate everybody sitting in on this webinar, and I hope you found the information useful and valuable. You have lots of contacts to reach out to with questions as well. So thank you, and have a nice afternoon, everyone, and thank you to all the presenters. Back to you, Zena.
Thank you, Eileen. As we indicated at the beginning of the webinar, the recording and the presentation will be posted on SBIR website under the Funding Opportunities webpage. Just keep an eye on that page, please, or reach out to me via email. And that will be it. Thank you to all our presenters, and have a good evening.